Okay. Thank you for voting me in to speak. My name is Carl Rubin. I'm co-founder of TiFi. We are a wireless broadband IPTV and other converged IP service provider to hospitality, hotel service, apartments here in the kingdom. And I'm here to talk about the so-called new Thai cyber law, which actually is not all that new. It was enacted into law last July, but only now, as of last week, August 23rd, are the last category of people required to do IP logging under the law actually did that become operative. So August 23rd, just last week, the law became operative with respect to IP logging for many of you in this room, potentially, who are subject to the law. And we'll talk about that a little bit more. The reason I got interested in it is because of this. These are my customers. And it turns out my customers have to comply with this law, as do I, as a licensed internet service provider. And before we start, just a couple of ground rules. Number one, my interpretations of this law are based on unofficial English translations. There are no official translations from the ministry as of this date. This is not legal advice. I'm not a practicing lawyer anymore. I used to be. This is for summary purposes only. There's some parts that I skipped about the law. It's not complete, but we catch the highlights today. No liability if I skip something or miss something or misstate something. And big thanks go to Tim Bass from one of the largest Thai cybersecurity companies in the kingdom, ACIS, for help in developing this. This part of this was actually developed for a cyber law compliance seminar that I helped arrange for the American Chamber of Commerce in my capacity as chair of the ICT committee. And finally, there's some controversial parts of this law. I'm just the messenger. So, all right. Okay, so let's get started. What the Thai Computer Crime Act does is essentially criminalize computer misdeeds. And in point of fact, it's not all that different from similar laws in other countries. There's one in Malaysia that's been in effect for more than 10 years. In the United States, many states, including Virginia, my own home state, and South Carolina have very similar laws. And the common thread among all of these laws is to criminalize unauthorized access to computers, in other words, hacking, as well as spamming and all sorts of fraud. Where Thailand takes the next step, and the really controversial part of this law, is the IP logging requirement and the identification requirements and the retention requirements. This is what distinguishes this law from the laws in neighboring countries and other places around the world. The law right now consists of two documents that we'll be talking about. The first document is the law itself, and the second document is a clarifying document put out by the Ministry of Information, Communication, and Technology called a notification. The law itself, we're going to take a run through the law very quickly. The law itself has 30 sections. The third section is important primarily because it contains two definitions that we're going to talk about a lot. Who's a service provider? Because if you're a service provider, then you're subject to the IP logging requirements. And what do you have to log? You have to log computer traffic data. So we're going to talk a bit more about that. But for now, just understand, if you Google this law, by the way, you should get one of the unofficial English translations. If not, I'll probably put both the law and the notification and maybe even this presentation up on our website next week. Just to go through, starting with Section 5, it goes through a litany of prohibited acts, criminal acts, starting out with basic unauthorized access in Section 5 to a computer or a computer network. If you go into somebody else's computer or their computer network without authority, without approval, that could earn you, it's a crime, and it can earn you up to 6 months in jail and up to a 10,000 baht fine. Now, if you hack your way in under Section 7 and bypass somebody's password, you're going to jail potentially for up to 2 years, and you'll have up to a 40,000 baht fine. And once you get in that computer that you hacked into, if you now start damaging or destroying data, that can earn you up to 5 years free room and board, courtesy of the Kingdom of Thailand, without a work permit, and up to 100,000 baht. Things continue to get more serious. Section 10 is essentially denial of service. If you launch a denial of service attack against someone, 5 years, 100,000 baht. Sections 12 talk about hacking into the nationally sensitive computer systems that affect national security, public safety, economic security, critical infrastructure. That can get you anywhere from 10 to 15 years in jail, 20 if someone dies as a result of your actions. Finally, viruses, Section 13, a year in jail. And if you embarrass a poo yai on the net, Section 14 and 16, you can get 3 to 5. So, those are some of the prohibited acts. This act is enforced by the Royal Thai Police Force. The enforcement authority under Section 18 gives the police the authority to come to your house or your business and demand statements from you, demand documents from you, demand data from you. They can copy data, they can seize hardware. But, like many laws, under Section 19, it has due process protections built in for the citizenry. The authorities must first petition a court to get the search and seizure authority, number one. Number two, they have to establish reasonable grounds to believe an offense has been committed or will be committed. If I put my old lawyer hat on for a minute, in the United States, the benchmark for getting that search warrant is not reasonable grounds, but probable cause. This is a higher standard in the US than it is in Thailand. But there has to be a reasonable basis for them to obtain a search warrant. And they have to get that warrant first before they come knocking on your door. They have to show you the court order. They can copy your data if they have the reasonable grounds and no excessive business interference. And the seizure is limited for 30 days, longer if they ask the court. So that's the basic rights that, and responsibilities under the Act. And basically, so far so good. This law, up until Section 19, 20, 21, 22, in that range, is about the same as any other law in any other country to criminalize bad acts via the computer networks and the internet. The problem, the next step, the issue I should say, starts with this Section 26. What 26 says under the law is that if you are a service provider, and remember that is defined in Section 3, and we're going to talk about it some more, you must record and store computer traffic data, another defined term, and hold it for 90 days. Longer if the police ask you. So, and then the law goes on to say if you don't do this, you can be charged 500,000 baht. Again, putting on my lawyer hat, one of the things the American Chamber, and in fact on behalf of all of the 30 foreign chambers of commerce in Thailand, will be asking the ministry is that 500,000 baht per day? Is it 500,000 baht per violation? Is it 500,000 baht for just not doing it for a bunch of times? So we don't quite know how severe this penalty is yet. But it could be, 500,000 baht is nothing to sneeze at anyway. But it could be much worse than that if it's a per day violation or a per violation penalty. So just keep that in mind. It's an unclear, the penalty is not quite clear in our opinion under the law as of this point in time. So if you're a service provider, you got a log. So the first question is, who is a service provider? If you look at Section 3, the definitions under the law, it says you're a service provider if you provide essentially internet service to the public via a network. That's what it's saying, either on your own behalf or on behalf of others. So the problem with this definition is it's pretty broad. Also, if you're an internet, if you're a data center under Section 2, potentially you're a service provider. It wasn't very clear. Was that meaning, just opening up to the public, but not necessarily a private network? No one really knew. So what the Ministry of ICT did is they issued this second document that we talked about called a notification. And this notification made it much more clear who is a service provider that is subject to the logging requirements under this law. And they gave 4 types of service providers, and they made it very clear. If you're one of these 4 types of service providers and you provide internet access to another, then you are going to be subject to the IP logging requirements under this law. So the first type is a telco, essentially a phone company, a mobile phone like True or TOT or TT&T that has your wireline, hardwire telephone service. A mobile phone company is a service provider and subject to this law. IP Star, a satellite operator, is subject to the law. And media providers, people that have fiber, people that have copper under the ground that deliver the internet. So UIH, Violin, people like that. It's this second category that really I think is going to be of interest to more people in this room. And they call it, the Thais call it an access service provider. If you're an access service provider, then you're subject to this law. Examples of an access service provider are ISPs, hotels that provide internet access to their guests and their employees, companies that provide internet access to their employees or their guests, academic institutions like the one we're sitting in right now, Chulalongkorn has got to do it because they provide internet access to their students and guests such as ourselves, and government departments that provide internet access to their employees. So that is a huge amount of people that is now subject to this law, that becomes a service provider and thus is subject to the logging requirements under this law. The other 2 categories are web hosting companies and all internet cafes. The second issue that comes up is, okay, if I'm a service provider, I have to record certain kinds of data. What do I have to record? And just remember, it's different for all 4 types. But the type that we're going to look at is B, because that's pretty much everybody in this room. So, going back to the law and the more general definition, if you look in the definitions of the law, you have to record computer traffic data. And what is that? Basically, in a nutshell, they say it's computer system-based communication showing sources of origin, starting points, destination, routes, times, dates, volumes, time periods, types of services. Again, very, very general. And so the ministry in this second document, the notice, tried to clarify with some detail, mostly successful, but there's still some questions we'll talk about what you have to log and hold for that 90-day period. So if you are a type B access service provider, if you're a type B type of service provider, basically a company, an internet service provider such as myself, a company such as myself, a hotel, anybody essentially in this category, this is the kind of stuff you need to log. And the overview here is IP header information, not content. All right? You do not have to log the content of your emails and all of that. It's the IP header information. So for internet logging, for instance, Thai today set up a authentication system. You need a username and password. Those access logs, whenever you log on to the system, have to be recorded and provided to the government if they ask for it under the law. The date and time of your connection, the user ID, which is that user ID you have, and your password, and your IP address. So if you have an authentication system, all of the IP authentication header data. Email, what do you have to do for the email type of activity? All of the SMTP logs, the header information, the sender's email, receiver's email, the status, the IP of the client, the date that you connected, the IP address of the sender, the user ID, and POP3 log information or IMAP log information. Now, I'm an ex-lawyer. I don't know exactly what that means, but I'm sure a lot of you in this room do. But essentially, again, it's the header information. It's not the content of the email. But you got to log it, and you got to keep it for the 90-day period. FTP logs, this is the stuff you got to have for this type of activity. The question that comes up now is, I don't have an FTP server. So the question is, do I have to deep packet inspect and see if that's the kind of traffic that you're moving and try and strip that header information out? Or is it only the guy who operates the FTP server that has to do it? The question in our minds at the Chambers of Commerce is it's currently not quite clear to us. The unofficial interpretation from the ministry is if you don't operate that FTP log, if you don't operate that FTP server, you're not responsible for that information. You cannot hold me to that, okay? Because it's not for certain. That is a completely unofficial interpretation. So for now, we're inspecting and yanking the information ourselves for our clients. Web traffic logs, same things. This is the stuff you got to do for that. Access logs, source IP instructions. This is the Usernet stuff that you've got to strip out and retain. And for internet relay chat or instant messaging, that's the information that you need to strip out and log for your retention. And that, essentially, is the current overview of the law as it now stands. So I hope that this was clear and that you at least gained some understanding of what has to be done. Questions?